I've never seen you wear glasses.
I know, my contacts were,
You wear contacts?
my glasses, my contacts were hurting my eyes, so I took them off.
Oh, okay.
Good afternoon, Your Honor.
Afternoon, Mr. Jaworski. Can you hear me all right?
Yes, Your Honor, absolutely.
Okay. Ms. Sipes, if you can unmute. There we go. Thank you. Ms. Sipes, can you hear me all right?
Yes, Your Honor.
Okay. Are we ready to go?
Yes.
Okay.
Yes,
Anybody,
Your
any witnesses that are going to offer testimony, if you please raise your right hand. You swear the testimony you're about to give should be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Okay. And I assume that is Ileana Silva with you, Mr. Jaworski, and Debbie Martinez with Mrs. Sipes.
That is correct, Your Honor.
Okay. Okay, Mr. Jaworski, you brought the suit. Go ahead.
Yes, Your Honor. Ms. Silva, can you again state your full name for the record?
Ileana Silva.
And Ms. Silva, did you purchase property in El Paso County this year?
I did.
Is that the property subject of this suit, 10512 Candlewood Avenue, El Paso, Texas?
That's correct.
And when you purchased that property, did you receive title?
I did.
And do you currently hold title to the 10512 Candlewood Avenue, El Paso, Texas property?
I do.
And is that title secured with a bank note?
Yes,
And do you hold title as a single person?
I do.
Now let's back up a little bit. Who owned the property prior to you?
Eduardo Silva.
And did he own that property as a single unmarried man?
He did.
Objection, Your Honor. She's asking for, well, he is asking for a legal conclusion and she's not qualified to give that testimony. That is the bone of contention in the divorce, and she's not able to answer that.
As far as he is a single man, is that what you're referring to?
Whether he held it is title as a single man.
Oh, is he held title? Okay. Okay, well, okay, well, let's go ahead. I'll rule on that as we go.
May I re-ask the question, Your Honor?
Sure.
Okay. And Ms. Silva, did he hold title to that property as a
Oh,
single
Well,
unmarried man?
Let's just go on from there. Let's go to
Oh,
the
okay.
next question.
Okay, I understand. Ms. Silva, I want to shift gears slightly and talk about Ms. Debbie Martinez. Did she ever occupy the premises at 10512 Candlewood Avenue?
She did.
Does she still occupy the home located at 10512 Candlewood?
She does.
And who is Ms. Martinez?
She's my brother's ex-girlfriend.
And while she was occupying the premises, did she ever pay rent to your brother?
She did.
Objection, Your Honor. That's hearsay. She doesn't have any knowledge of that.
Well, she can answer whether she knows it or not. She
Yes,
can
Your
answer whether she knows or not.
And I can lay the foundation, Your Honor, a little bit if the court would.
Just so I'm clear, is this Silva I'm trying to figure out who the parties are. You said the brother. Who is your brother?
If I may answer, Your Honor, her brother previously owned a residence.
That's the Silva you're referring to.
Yes,
Okay, in his, okay. Okay, so, and your last question was, I'm sorry?
while
Oh,
she
you're
was,
paying rent. Okay, go ahead and lay the predicate, whatever, lay the groundwork. Go ahead.
Ms. Silva, were you familiar with the financial arrangement that your brother had with Ms. Martinez?
Yes,
And part of that financial arrangement, was she required to pay rent?
yes,
Do you know how much?
Objection on her, and she still has to lay the foundation for how she would know or how she would be familiar.
Okay, Ms. Silva, I mean, Mrs., yeah, Ms. Silva. Do you have personal knowledge of whether or not Ms. Martinez was paying rent?
I do.
How do you have personal knowledge?
I know through digital transfers that I've seen.
Okay, well, go
I
ahead.
didn't hear her exactly. She knows through what kind of transfers?
Digital transactions that she has seen.
Well, what, can I take her on
Sure.
board, Dr.
Go ahead.
Honor? What digital transfers have you seen that show that my client was paying rent?
We have submitted an evidence for this court to review that
Okay.
includes that
How-
transaction.
Prior to this litigation, what, did you ever observe my client paying rent?
I did.
When?
For, based on my knowledge, she paid up until the point that they were
What-
broken up, which was in September of last.
Unresponsive, Your Honor.
Okay.
When did you ever personally observe my client pay rent?
I know knowledge that she did.
Objection,
I
Your
did
Honor. Then
see her do the transfer, but I know that there was transfer.
Okay, Ms. Silva, if you gain that information through somebody else, that's hearsay. If you've seen something or actually saw her pay rent, that's personal knowledge. So Ms. Sipes is asking whether you have personal knowledge or have you seen her pay rent?
I have not.
Okay,
Honor, if I may kind of
go
clean
ahead.
this a little bit, have you seen the rent receipts that she is?
Yes,
So-
I have.
Okay.
Your Honor, hearsay,
Well, would it be hearsay if it's receipts of your client?
if somebody else wrote them, Your Honor, other than her, she has no personal knowledge of it.
Well, she can deny that she can contest the receipts, but if they have receipts, I'm going to go ahead and allow them to present the receipts.
And yes, Your Honor, and that we have attached a receipt to one of the pleadings. I hope that made its way to your court when it got transferred
Okay.
from the previous. But I can supplement if the court does not have that receipt.
No, let's bring up what we're talking about. Would it be with your filing?
It was with my response to the plea to the jurisdiction, Your Honor. It was one of the last exhibits, actually.
Did you email any of this information in? I thought there were some exhibits, no? Did either?
It was, I'm not aware of what the court from the other JP court provided to this court. There was some pleadings from the previous, from JP3, and this evidence that I'm referring to, that we're referring to, is attached to our response to the respondent's plea to the jurisdiction.
Okay. Did either side, Ms. Sipes or Ms. Jaworski, did you all email anything into my court or no?
No, Your Honor.
Ms.
No,
Ms.
Your
Sipes?
Honor.
No, okay. So everything would be in Odyssey from the prior court.
Yes.
Yes, Your Honor.
Okay, so here's your response. You
It
see
is
that
the
on screen?
very last page, Your Honor. Should be, at least for my copy.
A lot, okay.
That one. Yes, Your Honor.
Okay, what is this purport to be?
The receipt by which Ms. Martinez was paying rent, one of the rental receipts, Your Honor, that my client is testifying about.
Okay. September rent and bills minus pool, okay? And how do we know this is from Mrs. Martinez?
I can continue with the testimony, Your Honor.
Go ahead.
Yes, Your Honor. And this rent receipt that we're talking about, how were you made aware that this was from Miss Martinez?
I was made aware through bank statements that I was privy to.
And is that part of some other litigation that's going on in different courts?
Yes.
Okay. Now it's going back to the rent. Did Miss Martinez ever pay you rent once you obtained title to the property?
No.
Okay, I'm gonna interrupt. When did you obtain title of the property? When did you purport to obtain title?
March 8th of this year.
March 8th of 2022. Okay, go ahead.
And Your Honor, that is attached to this same pleadings. It is further up in the, it's under Exhibit A. Keep going up. I'm sorry, Your Honor, keep scrolling upwards. It's one of our very first exhibits attached. It should be Exhibit A. It's a warranty deed.
Right here?
Yes, Your Honor.
Okay, so this was this
So
was closed at a title company?
Yes, the title company, I went through a title company to process this and settle.
In Florida?
No, my brother was actually in Florida at that time, so that's where he signed, but I signed here.
Okay,
And then, Your Honor, the first exhibit is Mr. Silva's warranty deed. So we've attached the warranty deed that Mr. Silva had, and then the warranty deed for Miss Silva.
okay. Okay, go ahead.
Okay. So just to clarify, has she paid any rent since the relationship dissolved between your brother, or has she paid any rent since the relationship dissolved?
No.
Objection, Your Honor, that's a misstatement. The relationship has not been dissolved. We're in County Court 5 presently on a divorce that was filed before this title exchanged hands.
Okay, I'm trying to get, we're get to the meat of this. Okay. What relationship was over? Are we talking about? Whose relationship are we talking about?
The brother and Miss Martinez, Your Honor.
Okay, were they married at one time?
Your
No,
Honor, we have filed a divorce. We have provided evidence in this case as well as the divorce case of such marriage. There's a statement as well as other evidence of the marriage that took place before this property was deeded to the brother of the plaintiff today.
Okay,
Your Honor, if
go ahead.
there is no, Ms. Sipes is, while not totally incorrect, she has filed for a divorce claiming a common law marriage. There was no marriage ceremony. There is no tax filings. In fact, we have attached documents here that Ms. Martinez has provided information as a single unmarried woman purchasing property in 2017, which is the same time frame that she's claiming to be married to Mr. Silva in this other action in a different court. It is our contention there was never a marriage. There was never a common law marriage. There is no integral intertwining here of the two issues to question the possessory interests that are at stake in this eviction
Okay.
proceeding.
So I'm trying to understand this case. So Ms. Sipes, what you're containing is that there's a common law marriage which was
Yes. In
completed.
2000, can I give a brief argument?
Sure, go ahead.
And I would defer it to the plaintiff's attorney if you'd like to give one first and outline what he says to
Yeah,
the facts.
Go ahead, Mr. Jaworski, and then I'll allow Ms. Sipes to respond.
Yes, Your Honor. I mean, of course, as this court knows, what we're here to decide today is who has the immediate possessory interest, superior possessory interest of this property. It is our contention that belongs to our client, Ms. Silva here, for several reasons. The lawful transfer of the title of property, which we've provided here. In addition, that there is no marriage, there was never a marriage. And by virtue of claiming there's a marriage, that doesn't integrally intertwine the issues of title and possession to the point that this court cannot provide a judgment in this case. We believe the court can clearly find for Ms. Silva in this case, can find that these purporting to be married is a stall tactic at best. There's documents attached to this response that shows Ms. Martinez purporting to be a single unmarried woman on federal paperwork that she is now claiming to be married at the same point in time, a common law marriage. Your Honor, we ask the court see through this, see through these smoke and mirror tactics, stall tactics for someone that's been occupying a premises rent-free since September. For all these reasons, Your Honor, we believe we've met our burden here by a preponderance of the evidence. We have the testimony has satisfied that. I'm further welcome to explore more testimony with my client if the court so needs us to further prove up this case, but we believe the court can clearly decide on the pleadings and specifically on the testimony that was brought forth here and the evidence attached to for my client. Thank you, Your Honor.
Okay. Mrs. Sipes?
Yes, Your Honor. Your Honor, we have filed a plea to the jurisdiction and we have attached certain documentation to that plea. My client has filed a divorce action before this eviction litigation was commenced, before any title policy was, and I don't know that a title policy was given. We filed a lis pendens in the county court files. I don't know whether there was a title policy ever issued.
When was the lis pendens filed?
February the 2nd of this year.
Okay.
With regard to our evidence of the marriage, my client has sworn that she and Mr. Silva agreed to be married, that they made that agreement in the state of Texas, and that they thereafter held themselves out as married to other people, to the public, and that they lived together. In fact, my client's daughter, not the daughter of Mr. Silva, had a quinceañera which was videotaped, where he was introduced as my client's daughter's stepfather. That's on videotape. That occurred before the purchase of the house. We have attached to our motion of the plea to the jurisdiction a transcript in a third litigation where the first wife of Mr. Silva and Mr. Silva were contesting custody of their son, where the attorney for Mr. Silva stands up and tells the court that my client is the wife of Mr. Silva. I have attached that transcript. The agent for Mr. Silva stood up in open court and told Judge Anderson that my client is the wife of Mr. Silva, and that occurred before so-called purchase this property. The attached also, Your Honor, as an exhibit to our motion is a statement of the attorney for Mr. Silva saying that the identification of my client in that third litigation identified my client as the wife of Mr. Silva. My client, I believe, will give testimony today telling this court that her husband told her they would file separately because the federal court did not recognize Texas common law, that it was unique to Texas. That is the same as well as the deed out of New Mexico, where he told her only Texas recognizes the common law marriage, but he has never done anything but represent to the court in the first litigation where he was in litigation with his former wife over the custody of their son. My client then proceeded to raise that child in the house. She made 1/2 of the mortgage payment every month since it was purchased thereafter. She has made capital improvements to that property out of her earnings, but they were community property because she earned that during the marriage. She has made not only capital improvements, but she has made repairs. She has continued to live there. There is no lease. There has never been a lease. There's never been a rental agreement. This is hotly contested where the plaintiff today in your court, the plaintiff today is a third-party defendant in the divorce in County Court 5. I do not believe they will show us a title policy today because I don't believe she can get one. I believe that her brother, the respondent in the original divorce action, has paid all of the payments on the mortgage since the litigation started. I do not believe that the plaintiff in your court has any wherewithal to purchase this property and that she did not purchase it for value. And I believe we'll be able to show that today. I don't believe this court has jurisdiction, according to the case law I have cited to you, an opposing counsel's statement that he's suing for title. He's want this court to say that she has title. This
No.
court can't have jurisdiction over title.
We don't, I don't have any jurisdiction to determine who title is in. I do have jurisdiction to determine who has superior right of possession.
Well, I believe we'll be able to show that my client has lived there since the day it was purchased and lives there today, despite partial hearings in the divorce court, which are scheduled for a big hearing in June.
Okay, I'm gonna kind of speed this up a little bit. Mr. Jaworski, what do you have? You mentioned something that where Mrs. Martinez represented to, I guess, on a filing that she was a single woman. What did you submit that?
I did, Your Honor. We submitted several things. We have pay stubs where she's purporting to be single. We have a FAFSA application where she's purporting to be single. We have her signature on MFA compliance addendums that are also attached to our response to their plea to the jurisdiction.
Here, where is it? Is this what you're referring to? What are you referring to? Is this?
That's one of the documents. Yes, Your Honor. That's one of the documents that we are referring to.
Where does she say she's single in this?
If you go to the next page, Your Honor, under the Donna Anna, she checks the box as a single person and then signs on the third page there. There's also, it's sprinkled throughout these documents, Your Honor, multiple times where she also on the MFA compliance addendum, it says to include all members of the household. So, Your Honor, even if we're supposed to take the argument at face value from Ms. Sipes on the MFA compliance memorandum, it says to include all family members, roommates, significant others even.
Which one is that?
Um,
Right here, MFA compliant.
yes. She was a daughter and a son, not even a boyfriend, not even a significant other, certainly not a spouse. Your Honor, again,
Ms. Sipes?
and if I may, just one more point, Your Honor, with regards to the transcript that Ms. Sipes is very heavily relying on, we have also attached the exhibit provided to the court, the witness list under Exhibit A, where she's also listed to the court as a girlfriend. If the court looks at the transcript carefully, it seems like it's one of those situations where they're trying to get someone into the courtroom saying they're a spouse. We have no other outside knowledge of who purported that, if that was an attorney saying that that's a spouse, but there's an exhibit list and a witness list where she's listed as a girlfriend. Furthermore, just because someone is claimed to be a spouse in court by some attorney doesn't satisfy the common law legal elements to necessarily intertwine title and possession in this case. We believe the court can easily find that the superior possessory interest in this property belongs to my client. Thank you.
Okay, Ms. Sipes, your response?
My response, Your Honor, is that she will testify that her husband told her New Mexico did not recognize common law marriage in Texas. She will also testify that he told her that the federal government did not recognize common law marriage and that she could be in violation of the federal criminal laws for making a misrepresentation. And therefore, that's why that occurred. In the transcript, which occurred in County Court 5 in front of Judge Anderson, Mr. Silva is present, my client is present, and the first wife of Mr. Silva has attempted to have her exit the courtroom because she's a material witness and not related to Mr. Silva. Mr. Silva is there and he sits there as his attorney,
Yep.
Lisa Hayes, says that they're married. These it's all set out in our plea to the jurisdiction. We have a video of him being addressed and introduced at the quinceañera prior to the purchase of the home, that where he is the stepfather of my client's daughter.
Okay.
We have letters from him to her, or notes, not letters, but greeting cards and other items that we can introduce to show he acknowledges the relationship. But it does,
I understand, Ms. Sykes, but all of this information that you're providing to court, that's going to be the subject matter of your suit in county court. To show that there was a common law marriage and then you're going to get a divorce. But from the face of the documents and from the record, it appears that, superior right of possession is in the title holder, which has been filed of record. And that's what I'm going to order. That's what I'm going to grant. Because that's on the face of it, that's what it appears to be. And I find that, I mean, you're going to dig deeper into the county law case and you might establish that she does have some ownership rights, but it hasn't been established as of yet. So
I believe that we disagree, Your Honor, and I respect your ruling. I would ask the court to look at the affidavits that are on record in this file. In
I've
setting
looked
the
your plea,
bond.
your pleas on the screen. I've looked through this. Is it in response to your plea? Is that what you're referring to?
Is the court doing that, or is
I
counsel?
am. You tell me which page to go to.
On the transcript?
Okay, on the transcript, I think that's down here. Is this what you're referring to?
Page.
It's the excerpt of final hearing from the
Page
interest of
8.
what? Page 8?
Page 8.
Okay. Okay, Ms. Hayes, she's a spouse of my client, Your Honor. Yeah, the spouse can stay in the courtroom. Okay, again, that may very well be, but there's all kinds of possibilities. He could have bought it as his separate property with his separate funds. I don't know, but you're going to get into that in county court.
Yes, Your Honor. And I respect your ruling. I'm not arguing with that, but in scheduling the bond in this case, I would ask the court to take notice in your record of the filing of the affidavits. We subpoenaed certain records here today of the plaintiff and another relative. The process server in trying to serve them with those subpoenas was met with absolute difficulty and never ever got them served. There is consequently, I would represent to this court that there were service fees charged to my client because of their refusal to be served through their attorneys. And the rules in JP court allow us to serve the attorney for the litigant with a subpoena for their client. They avoided that service after making representation, and consequently, it cost my client the sum of, I think, almost $750 due to the numerous attempts to service. So
Your
we
Honor,
ask the court to take cognizance of that in setting the bond.
Okay, Mr. Jaworski?
yes, Your Honor. Your Honor, all parties were at court physically last Thursday. That would have been a great time to serve parties when you know that they're going to be somewhere. That was not done. Furthermore, Your Honor, this individual has been living rent-free since September. We ask that the court take that into consideration when regards to setting the bond. Furthermore, and additionally, Your Honor, with regards to filing pleas to the jurisdiction, I would submit frivolous pleas that are baseless in fact or law, which we have had to respond to, spend several hours digging into the topics, digging into the case law research, digging into what the 8th has said about adverse possession with regards to pleas to the jurisdiction. Your Honor, we ask that the court take that into consideration, and potentially, if we're asking that the court, and in our response, we ask for attorney's fees, we would ask the court for those as well.
What are you asking for in attorney's fees? Did you your petition you asked for them?
In the response, Your Honor, to the plea to the jurisdiction, we asked for reasonable attorney's fees.
Okay. Okay. What is? I'll ask each of you. What Mr. Jaworski or your client, through your client, what do you believe the value of this house is? What do you believe the value of the house is?
I purchased the house for $129,000.
Okay, Mrs. Sipes, and through your client, what do you believe the value of the house is?
268,000 is what the county and the school district of El Paso County say it's worth.
All right, so it's on CAD for 268,000?
Right. I don't believe that the plaintiff has shown or can show that she purchased it for value. She merely assumed what was owed on it.
Okay. And
This
then I know
Brought up on the court.
Ms. Sipes, your position and your client's position is that she was not paying rent, correct?
She never paid rent. They divided expenses. Plus my client made capital improvements to the property. She paid for most of the down payment on the property.
Okay. And Mr. Jaworski, your client, what do you contend that she was paying for rent each month?
The rent receipts, Your Honor, have varied between $900 and $1,000 based off the utilities,
Based off the utilities, I don't understand that.
based off of the pool maintenance. Splitting the maintenance for a pool.
Oh,
Sometimes, Your Honor, like in the summer months, electricity may be more to cool or heat the house.
okay. I'm gonna award possession to Ileana Silva. I'm gonna set the bond, $129,000 house, 10% generally is what you set the bond at. You stated the rent was $8. I'm gonna set the bond at $1,000.
Thank you, Your Honor.
Thank you all. Now, we will email a copy of this order to each of y'all.
Thank you, Your Honor.
Have a
Thank you.
good afternoon.
You too.
May we be excused, Your Honor?
Yes, sir. Thank you.
Thank you.